Welcome to this explainer. I'm your host, and today we're going to unpack the strict ethical framework and disciplinary mechanics that govern the Indian legal profession. Look, if you're planning to wear the robes and step into the courtroom, you have to understand that the privilege of practicing law comes with immense, unyielding responsibilities. Today, we're looking at the absolute core of what it means to be an advocate under the law. Okay, let's run through our agenda for today. 1. The path to legal practice. 2. The 7 lamps and duties. 3. Misconduct and disciplinary proceedings. 4. Accountancy rules for lawyers. And finally, 5. Bar bench relations and strikes.
Section 1. The path to legal practice, from Mughal vakils to the Advocates Act 1961.
Tracing the history rapidly, it's fascinating to see exactly how we got to where we are today. During the Mughal period, the legal system relied heavily on an informal class known as vakils. Fast forward to the British era, specifically 1926, and the Indian Bar Councils Act attempted to create some uniform regulation, but we still had these incredibly fragmented classes: barristers, pleaders, muhtars. It actually wasn't until post-independence, with the truly landmark Advocates Act of 1961, that this entire scattered system was consolidated. That 1961 Act unified the profession under one single category, the advocate, and it firmly established the Bar Council of India as the ultimate regulatory authority.
So how do you actually get there today? Well, here's the hard truth about the Section 24 enrollment process. You start with Step 1, your application to the State Bar Council, which is followed by Step 2, the verification and the oath-taking ceremony. But listen to me carefully. Merely getting enrolled on the state roll is not enough. To truly practice, you absolutely must conquer Step 3, passing the All India Bar Examination, or AIBE, within 2 years of your enrollment. Only then do you reach Step 4 and secure that vital certificate of practice.
Let's break down a modern landmark case using the FIRAC method: facts, issue, rule, application, and conclusion. Take the 2023 case of Bar Council of India versus Bonifoy Law College. The facts and issue here: people challenged the AIBE, arguing the BCI lacked the constitutional authority to mandate a post-enrollment exam. They claimed it flat-out violated their Article 19(1)G right to practice any profession. But the Supreme Court stepped in and applied the rule perfectly. Article 19(1)G is always subject to reasonable restrictions in the public interest. So the conclusion? The court ruled that the AIBE is absolutely constitutionally valid. The BCI has unquestionable authority to enforce minimum standards of professional competence before letting you loose on the public.
Section 2. The 7 lamps and duties, the Code of Ethics.
Once you're in, you must internalize Justice E.A. Perry's 7 Lamps of Advocacy. Now, these aren't just quaint historical ideals, they are your daily survival tools: honesty, industry, wit, eloquence, and judgment. These are the absolute bedrock of your competence. But I want to particularly highlight courage. That's your sworn duty to defend unpopular causes fearlessly, without ever yielding to public pressure. And equally important is fellowship. That means maintaining unwavering respect and courtesy for your opposing counsel. Remember, we fight hard on the law, but we remain colleagues at the bar.
Building on those lamps are your essential duties under the Bar Council rules. First, you must abide by the cab rank rule, meaning you cannot simply refuse a brief without a very good, sufficient cause. You must refuse to act illegally, even if your client demands it, and you must protect client confidences fiercely. The crucial point here is really understanding your legal English terms, specifically your fiduciary duty. A fiduciary relationship means the connection between you and your client is built on absolute sacred trust, and that heavily dictates how you handle their money.
To see exactly what happens when that sacred trust is violated, let's apply FIRAC to the 1979 Supreme Court ruling in Vicheji Rangadurai v. D. Gopalan. The facts: an advocate received money on behalf of his client and shamelessly spent it for his own personal use. The issue was whether this constituted grave professional misconduct. The Supreme Court brought down the gavel hard. The rule they applied was simple but strict. A fiduciary relationship was breached. Personal use of a client's money destroys public confidence in the entire legal profession. The inescapable conclusion: misappropriation of client funds constitutes grave professional misconduct and merits immediate removal from the rolls. Period. Section 3. Misconduct and disciplinary proceedings, facing the consequences. Building directly from that breach of duty in Rangadurai into the strict mechanics of disciplinary action, we really need to understand how misconduct is defined. Under Section 35 of the Advocates Act, misconduct is a very wide concept. It's vital to distinguish between 2 key categories here. First, professional misconduct. This relates directly to your practice of law, things like misappropriation, perjury, or ignoring client instructions.
Other misconduct, however, refers to your actions completely outside the profession that affect your fitness to practice. I'm specifically noting the English term moral turpitude here. If you catch a criminal conviction involving moral turpitude, meaning conduct that is fundamentally contrary to justice, honesty, or good morals, your fitness to wear the robes is instantly compromised.
So when a complaint actually gets made, who hears it? Well, the hierarchy is clearly delineated. The State Bar Council Disciplinary Committee holds original jurisdiction. They are basically the first responders who investigate initial complaints. Now, if an order is passed there, the Bar Council of India's Disciplinary Committee steps in to act as the appellate body, though it does also hold original jurisdiction in a few select scenarios. Both of these committees are composed of 3 members, which ensures a panel of experienced peers is reviewing your conduct.
The procedure they follow is incredibly rigid and structured. Step 1. A complaint is filed, or the council acts on its own motion. Keep the legal term suo motu in mind there. Now, if they look at the complaint and see absolutely no initial evidence, meaning no prima facie case, it gets summarily dismissed at Step 2. But if there is substance, Step 3 triggers a formal notice and a hearing guided strictly by the principles of natural justice. Finally, Step 4 delivers the order. They have options. They can dismiss the charge, issue a mild reprimand, suspend you from practice, or inflict the ultimate professional penalty, removal from the rolls.
But sometimes the misconduct occurs right in front of the judge. Let's Farak a wild one. In Re Vinay Chandra Mishra from 1995, the facts are glaring. An advocate actually abused and threatened high court judges. The issue? Could the Supreme Court completely bypass the Bar Council's disciplinary mechanism and directly suspend an advocate for contempt of court? The rule applied was Article 129 of the Constitution, granting the Supreme Court inherent power as a court of record. The conclusion was huge. The Supreme Court absolutely has the inherent power to suspend advocates for contempt, resulting in a severe 3-year suspension right then and there. This controversial landmark case shows you exactly what happens when an advocate disrespects the bench.
Section 4. Accountancy rules for lawyers. Protecting the client's trust. Managing money correctly is how you avoid the disastrous, career-ending fate we saw earlier. As an advocate, you're not just arguing, you're running a practice. Under BCI rules and the Income Tax Act, you are strictly required to maintain specific, highly transparent financial records. You've got to keep a cash book, a bank book, a proper journal and ledger, a bill book, and importantly, a client's account register that separately logs the money received on behalf of every single client. You simply cannot treat your law practice like an unorganized piggy bank.
And let me be perfectly blunt about BCI Rule 23. There must be absolute separation of funds. Client money must be kept entirely, 100% separate from your own money. There can be absolutely no mixing of funds ever. Listen to me. Using a client settlement check to pay your office rent, even if you fully intend to pay it back tomorrow morning, is an absolute violation of your fiduciary duty and a fast track to being permanently stripped of your robes. Section 5. Bar bench relations and strikes. 2 arms of justice. Looking at the broader ecosystem now, we're examining the delicate, sometimes highly tense balance of power between the advocates standing at the podium and the judges sitting on the dais. The bar and the bench are 2 arms of the exact same justice delivery system. This relationship absolutely demands mutual respect. An independent bar is essential for holding government power accountable, defending those unpopular causes we talked about, and ensuring the rule of law. However, while a fiercely independent bar is necessary, this independence cannot ever be allowed to paralyze the courts themselves. Which brings us to a final Constitution bench ruling you must firmly commit to memory, ex-Captain Harish Uppal versus Union of India 2003. Let's FIRAC this one last time. The facts? Frequent lawyers' strikes were completely paralyzing court work across the country. The issue was whether advocates actually have a legal right to strike under Article 19(1)(g). The Supreme Court delivered a resounding no. The rule applied is that an advocate's primary duty to the courts and to the clients completely supersedes any right to strike. The conclusion was absolute. Bar associations cannot legally demand strikes. Only token, symbolic protests of one single day, protests that do not affect court proceedings, are permissible. The mandate is crystal clear. Let me quote it. Lawyers have no right to strike in the legal sense. Strikes affecting court work are illegal. This isn't just a friendly guideline or a gentle suggestion. It's a Constitution bench mandate. The Supreme Court is firmly prioritizing the vulnerable litigant, the everyday citizen waiting for justice, over the collective grievances of the bar. I want to leave you with this provocative thought as we wrap up. Does the absolute ban on strikes fundamentally protect the vulnerable litigant's right to timely justice,
Or does it permanently weaken the bar's ability to collectively resist systemic oppression and judicial overreach? It's a heavy question. Weigh the strict ethics of the profession against the very real need for a powerful, independent bar, and I strongly invite you to explore this complex dynamic further in your own study. Thank you for joining me in this explainer. Keep studying the law and uphold the robes.